In this video, I'm going to reveal a rather nasty loophole that the police have been known to exploit, and whether or not you should be worried about this too. So I've had various emails with various questions, all revolving around the same topic. That is, if you're arrested by the police or not arrested by the police and interviewed under caution, what your legal rights are and whether those rights can be exploited. One of the very common questions that comes up is that if you go for a voluntary interview, what are your rights under said voluntary interview? Well, this is where this nasty loophole comes about, which has even been reported in the Law Gazette, but more about that in a little moment. So many of you might be familiar with the Police and Criminal Evidence Act of 1984, commonly referred to as PACE. This governs lots of different things, such as what happens when you're arrested, and also there are what's referred to as the PACE codes, the Police and Criminal Evidence Act codes. These are codes by which the police must operate, and again, more about that in a little moment. And to address one question in particular, which forms the basis of this nasty little loophole, I'm going to talk about Section 58, which is access to legal advice. And as I read this out, I want you to drop in the comments what you think the nasty little loophole might well be and why it led to a lot of people distrusting the police, among other reasons, when it comes to legal advice when being interviewed for a suspected involvement in an alleged offence. So fairly plainly, Section 58 states that a person arrested and held in custody in a police station or other premises shall be entitled, if he so requests, to consult a solicitor privately at any time. This is rather broadly understood to mean you have a right to free legal advice. And just in case you're wondering, because some people do, whether it's the word he in this sentence, that's not the loophole, because most legislation does refer to he. It's not being sexist, it's just the way it was drafted. It applies to any person and any age, unless of course there are minimum age restrictions, such as the minimum age of criminal responsibility, which does vary from jurisdiction to jurisdiction, so make sure you take that out. Interestingly, for those in the United Kingdom, and to please our Scottish friends by mentioning it, the minimum age for criminal responsibility in Scotland is 12, but in England and Wales it's just 10. Coincidentally, in Northern Ireland it is also 10, but this is against the Youth Justice Review team's recommendation that this should be revised to 12. But that's not why you're watching the video. Back to Section 58 of PACE. Subsection 4 provides that if a person makes such a request, he must be permitted to consult a solicitor as soon as is practicable, except to the extent that a delay is permitted by this section. And such a delay is provided by Subsection 6, which is A, in the case of a person who is in police detention for an indictable offence, and if an officer of at least the rank of superintendent authorises it. In simpler English, that means a delay is only possible if a police officer of the rank of superintendent or above authorises such a delay. And just as the briefest of interludes, none of this section is sponsored, by the way. Lots of people have asked me for my favourite Chinese dishes and recipes. So of course I've got two go-to places. First of all, my dear wife's channel, Easy Chinese Cooking, which is linked in the description below for traditional Chinese dishes. Go and check that out. I hope you enjoy those dishes there. But also Zhang's Food Workshop, who has his own book out as well, which is also linked in the description below, so you can get my wife's versions, which are the traditional Chinese cooking, or the takeaway versions from Chin and Chew on Zhang's Food Workshop. As I said, not sponsored, but Chin and Chew also have their book out for traditional Chinese takeaway dishes that you can find in this book. Back to the video. There are also various rules about how long you can be held in custody and various other rights on arrest, but sticking with the point of access to legal advice once more. Did you spot what could be the loophole in this section? Let me know in the comments and write out what you think it is so that you can find out whether you were right and no cheating. Back to read the wording once more so that you can have another think about it. A person arrested and held in custody in a police station or other premises shall be entitled, if he so requests, to consult a solicitor privately at any time. So working backwards, let's look at some snippets of those wording and determine whether or not those form a loophole. We've already said that the word he doesn't provide the loophole, but how about the words if he so requests? Well, this could be a loophole if the person doesn't know that they are entitled to free legal advice. However, this is not really a loophole because when we look back at those PACE codes that I mentioned earlier on, the initial action under the normal procedure for detained persons is contained within Section 3 of Code C of PACE, at least the revised version, which says that when a person is brought to a police station under arrest or arrested at the station having gone there voluntarily, the custody officer must make sure the person is told clearly about and then all of their rights, which includes the right to consult privately with a solicitor and that free independent legal advice is available as in Section 6. So on the basis that the person must be told that they have access to legal advice, that's not really a loophole, because if they were not told that they had access to free legal advice, then this would be a breach of Code C and therefore potentially render the entire interview inadmissible. So let's go back to Section 58 to work out what this loophole is or was. A person arrested and held in custody in a police station or other premises shall be entitled. Now, you might have guessed it by the process of elimination by now that a person arrested and held in custody in a police station or other premises shall be entitled to such advice. So for those of you that said this is the loophole, well done, because that's exactly what it is. In 2012, an article made it to the Law Gazette, in which Richard Atkinson, the chair of the Society's Criminal Law Committee, told the Gazette that police was circumventing the Police and Criminal Evidence Act 1984 by interviewing suspects at home without a solicitor present, because the wording provided that only if one was arrested and detained at a police station or other place, then they had the right to free legal advice. Atkinson said in the article, the police are not acting unlawfully, but exploiting a loophole in PACE to circumvent people's rights to independent legal advice, with Section 58 of PACE specifically providing that only a person held in custody in a police station was entitled to consult a solicitor, but it did not mention suspects interviewed elsewhere. The Society wrote to the Home Office proposing that the Act should be amended to provide for independent legal advice wherever an interview with a suspect took place. A government spokesperson responded to say that the Police and Criminal Evidence Act sets out a person's right to free legal advice when being interviewed voluntarily under caution at a police station, and that they were working to ensure that the codes of practice accurately reflects the rights of suspects interviewed elsewhere. Robin Murray, a committee member of the Criminal Law Solicitors Association, said that he was shocked when a serving officer told him that police had got wise to the fact that they did not need a solicitor present if they interviewed suspects at home, saying that it's a naked and cynical attempt to circumvent suspects' rights, eroding at a stroke of the protections provided by PACE. However, you'll be pleased to know that the most recently edited version of the PACE codes provides as follows. Under Section 321, information to be given when arranging a voluntary interview. If the suspect's arrest is not necessary, but they are cautioned as required in Section 10, the person who, after describing the nature and circumstances of the suspected offence, gives the caution must at the same time inform them that they are not under arrest and that they are not obliged to remain at the station or other location. The rights, entitlements and safeguards that apply to the conduct and recording of interviews with suspects are not diminished simply because the interview is arranged on a voluntary basis. So whilst this was a fairly nasty loophole that was probably exploited for quite some time, the law has now been clarified so that you do have the right to free and independent legal advice regardless of whether or not your interview is voluntary and regardless of whether it's at a police station. However, before I let you go, a few other things about voluntary interviews that you should still be aware of. First of all, it may seem like a less formal interview, but that doesn't make it a less serious interview. And in some cases, it could well be the police trying to find out enough information so that they can arrest and charge you. Whilst on the one hand, voluntary interviews may allow the police to exclude you from their investigations without the need to arrest, detain you and then interview under caution at the police station, it could well be that the police don't have enough evidence or information to arrest you, much less charge you with an offence. But they may do so if they interview you, even if it's voluntarily. So if you think to yourself that you want to go to a voluntary interview and you decline your right to free legal advice because you think it makes you look guilty, which it doesn't by the way, you may inadvertently end up giving away information to the police during a voluntary interview that you wouldn't otherwise have done because you're not obliged to stay there because you're not under arrest, which might be enough information for the police to arrest you and even charge you with an offence, whereas they wouldn't have done so otherwise. And it's also worth remembering that you don't have to go with the duty solicitor. You can instruct your own solicitor and pay privately, and you are still entitled to do this. That right doesn't disappear just because you don't want the free version. And all of the other rules that apply to PACE interviews whilst under arrest also apply to voluntary interviews, which includes the right to free legal advice. It also includes the right to inspect the PACE codes. It also means police must give you information about the offence that they suspect that you've been involved with or that you've committed. If you need an interpreter for the interview, the police must get one, and so on and so forth. But remember, if it's a voluntary interview, you are not under arrest and you are free to leave at any stage. But any information that you give the police officers may give them cause to arrest you, and even if you refuse to turn up for a voluntary interview, they may arrest you anyway. Inviting you in for a voluntary interview does not necessarily mean they don't have enough information to arrest you. Remember, it's only a reasonable suspicion that you've been involved with or committed an offence that can lead them to arrest you to bring you in for interview. Offering you the voluntary interview may just be a way of saving everybody time to afford you the opportunity to explain yourself, with the benefit, of course, of free legal advice. So remember, as always, none of this video can be taken as formal legal advice because I'm not talking to you about your personal situation. This has just been a general overview of what has been a rather nasty loophole exploited for some time, which now shouldn't be. And now that you know about it, it shouldn't happen to you either. So in the meantime, please do smash the like button if you found this video useful and interesting. Please make sure you're subscribed, and as always, thank you for watching.